Hi everyone and welcome to episode 2. The first thing that I wanted to mention this afternoon was that I've just been on a virtual site visit. I'm doing a CPO for a road scheme up in Birmingham, but obviously I've not been able to get out on site and have a look around myself yet. So one of my witnesses suggested that we have a Zoom meeting, which we did, and he shared his screen with us all and brought up Google Street View and then walked us through the entire scheme. It was great, to be honest, although you're obviously pretty dependent on Street View being up to date, and there was the odd shot where there was a bus blocking exactly what I wanted to see, but as a workaround whilst the current situation lasts, I thought that it was a good one. So the focus of this episode is on the High Court decision in Sawkill and Highways England, which was handed down on Friday the 3rd of April. The facts are that Highways England has applied for a DCO in respect of the A303 and is proposing to tunnel near to Stonehenge and through a chalk aquifer that lies under the claimant's land. To be able to design the tunnel works, Highways England needs to carry out pumping tests, and that involves constructing boreholes and discharging water onto the claimant's land. According to the claimant, it's something like 45 million litres of water. The two questions before the High Court were, first of all, is Highways England entitled to rely on Section 172 of the Housing and Planning Act 2016 to enter onto the claimant's land to carry out the tests? And secondly, does discharging a very substantial amount of water fall within the scope of the power to undertake a survey? In short, Mr Justice Dove has held that the answer to both of those questions is yes. So, taking the questions in order, on the Section 174 question back in 2017, Highways England had applied under Section 53(1) of the Planning Act 2008 for authorisation to undertake surveys. The Secretary of State granted authorisation and the survey work was carried out in 2018, including pumping tests and discharge of water onto the claimant's land. But negotiations over access to the land to carry out additional pumping tests were unsuccessful, and so in 2019 Highways England gave notice under Section 174 of the 2016 Act that it intended to exercise its power under Section 172. That part of the 2016 Act, of course, relates to compulsory purchase, and the claimant then applied for judicial review. The claimant's argument was that it wasn't open to Highways England to use the Section 172 power in the 2016 Act because where a party wants to carry out surveys that are associated with a DCO and needs to gain entry to land to do so, then the relevant power is Section 53 of the 2008 Act. So the claimant contended that the 2008 Act provides a comprehensive statutory code for all DCO applications, and Section 172 of the 2016 Act doesn't provide an alternative to the Section 53 power. And that, in the claimant's contention, is because of the legal maxim that the general words in a later statute can't exclude the specific provisions of an earlier statute. I'm just going to call it the maxim. Highways England argued that the powers under Section 53 of the 2008 Act and Section 172 of the 2006 Act overlap, and Highways England can choose which power to deploy when it needs to gain access to land in order to undertake a survey. Now, if you're wondering why does it matter which power Highways England uses, then the important point is that Section 53 requires authorisation from the Secretary of State, whereas Section 172 does not. Under Section 172, an acquiring authority can authorise entry onto the land for survey purposes. And Highways England is authorised by Section 239 of the Highways Act 1980 to acquire land for the construction of a trunk road. So that means that it is an acquiring authority for the purposes of Section 172 of the 2016 Act. Anyway, the claimant argued that there's no indication in Section 172 of the 2016 Act that it's meant to supersede the specific procedure that's provided by Section 53 of the 2008 Act in relation to DCO applications, and the claimant also noted that Section 172 of the 2016 Act is a general power to survey that's granted to Highways England in circumstances where it's exercising compulsory purchase powers, and often, of course, that won't involve making a DCO. Mr Justice Dove rejected the claimant's contentions and held that Section 53 and Section 172 are overlapping, and Highways England can elect which one to invoke where it's promoting a DCO. He noted that nothing in the language of Section 172 excludes cases where the acquiring authority, so Highways England here, is promoting a DCO. and also that there's no material difference in the nature of the powers involved, so there was, in his view, no conflict and no inconsistency between them. Mr Justice Dove considered the point made by the claimant that the Secretary of State's approval is required under Section 53. The claimant argued that that was an important procedural safeguard. But Mr Justice Dove noted that any individual can, of course, apply for a DCO, whereas the Section 172 power is granted to acquiring authorities only, so there's not the same need for supervision by the Secretary of State. The second ground of challenge was that in any event the term survey in a statute doesn't encompass the discharge of very substantial quantities of water onto the land, so the claimant argued that where there's a power that authorises entry onto land in order to undertake a survey, that doesn't authorise the activity of discharging water as a consequence of the pumping tests. The claimant said that where the activity deprives the landowner of the enjoyment of his land and amounts to prolonged or even temporary disposition of the land, then it's not a survey and it amounts to expropriation. Mr Justice Dove began by looking at the details that are required by Section 174 of the 2016 Act to be contained in the Notice of Intention to exercise the Section 172 power. These include activities such as boring, excavating, leaving apparatus on the land and taking samples. Mr Justice Dove also noticed that where surveys are required to secure compliance with the EIA Directive and or the Habitats Directive, that might involve, for example, trial trenches for archaeological surveys. So the statute contemplates that survey activity might include elements that impact on the landowner's possession and enjoyment of the land, and that involve, in effect, temporary displacement of the landowner. One point to note here is that the claimant argued that the boundary between a legitimate survey and effective temporary dispossession or expropriation is a matter of judgment and is fact-sensitive. Mr Justice Dove doesn't address that argument expressly, but it's clear from the judgment that at any rate he's not persuaded that there is a clear distinction between legitimate survey work and temporary dispossession. So, in other words, even if the activity does temporarily dispossess the landowner of the land, that's no bar to the activity being survey work and remaining within the scope of the 2016 Act. Other than that point, the reasoning in the judgment is understandably tightly confined to the facts of the case that was before the court. So if in due course you need to work out whether another example of survey activity falls within the scope of the 2016 Act, then the most helpful point is probably this from paragraph 51 of the judgment, where Mr Justice Dove says, if an activity is properly understood to be within the scope of Section 1743, it should be understood as being within the scope of a survey for which there is power under Section 172 of the 2016 Act. So I'd say look to Section 1743, and if the activity falls within the scope of that section, then it's survey work. That said, Mr Justice Dove did accept that Section 174 doesn't exhaustively define the term survey, so in my view there probably is scope to argue in another case that activity that's not mentioned in Section 1743 nevertheless falls within the term survey. Anyway, that's everything on Sawkill. I hope it was useful, and take care.